after she's found her phone. Have you got it? No. I think it's all right. She is a British barrister and politician who has held roles as a government minister, as police and crime commissioner, and as the Victims Commissioner for England and Wales, when she represented the striking miners. She is one of the most distinguished barristers in the land and was awarded the DBE for her preeminent contributions to the field of law. She is also a KC or King's Counsel. Since May this year, she has been the chair of the Criminal Cases Review Commission, and today she will talk about the issues facing the criminal justice system and what is being done to resolve those issues. Deviera Bad, we are very pleased to welcome you to Islington iu3a.
Well, that was a fantastic introduction, which I truly don't deserve, especially since I A, lost my phone, and B, spilled the coffee. There was a time when I was doing a jury trial when, happily, the judge was quite a long way away, but my phone, in the middle of my own jury speech, my phone went off in my pocket. And what was I to do? The judge didn't seem to hear it, so I just waited because it would go on answer phone. And at the end of the day, when the case was all over and the jury were free from their oaths and everything, I was just going out and the foreman of the jury came to me and he said, "God, we thought you were clean when your phone went off." So I may have helped my client, who knows? Look, what I'm going to talk about, reasonably briefly and then open it up to questions is what's happening in the criminal justice system now and where it is to have made all of this happen. So it is a time of all change. And as your chair has kindly said, I am, when everybody gets their job back, a KC. But when I got it, of course, I was a QC. And I was a wholly defence barrister. I never prosecuted, except occasionally for Greenpeace, prosecuting environmental cases. But we were sort of lefty chambers, really, who thought that the establishment was was against the person who was charged, and they needed good, strong representation. So I spent about 20 years doing that. And when you become a KC, then the question is where you can go next. And unless you want to be a judge, there isn't an obvious answer. What I thought I would do instead would be to try and use such powers of advocacy as I have in pursuit of causes rather than, as it were, keeping the criminal justice system fair, which is how, of course, barristers see their role on the two sides. So I did, in fact, succeed in getting into Parliament, probably mostly to try and bring some changes to the criminal law. The law of homicide was changed a little bit whilst I was there to make things fairer for women who kill their violent partners. I became Solicitor General, and we got some myth-busting directions about rape into the Crown Court Compendium. That's just about the fact that rape myths beset rape trials even now, but it's very well known to the courts that they are wrong. And so we drafted a series of directions that the judges have in a book, which when they direct the jury about facts and how to approach them, they can say, this is a myth, don't rely on that. And I finally was very proud to take the Equalities Act 2010 through all its common stages. And that was shortly before I said goodbye to the House of Commons when we lost in 2010 and I lost my seat, and then I became a Police and Crime Commissioner. 7 very interesting, very different years, but interestingly that is when victims provision changed and the provision of victim services was put down to PCCs, Police and Crime Commissioners, and also to mayors. We have an increasing number of mayors, of which there's one here, but there's West Yorkshire now, there's Northumbria, and so victims stuff came down there. And toward the end of my period as a PCC, I became very interested in victims' work and became the Victims Commissioner for England and Wales. And when I left that, I did an inquiry about Greater Manchester Police for the Mayor there, and some work about devolution of probation and youth justice for the Welsh Government who would dearly like to have devolution of those aspects of the criminal justice system, and now I chair the Criminal Cases Review Commission, the body designed to tackle miscarriages of justice. So clearly I'm a person who can't hold a job down for very long. And I have seen, most sides of criminal justice, and that's how I hope I present it. But let's just get to where we are today. We have, as you know, jury trial. It's a hugely important talisman kind of setup for many of us. We also have magistrates court. I would be surprised if there aren't some magistrates amongst you. And of course, magistrates are very important, the bedrock of our criminal justice system, intended to be local people trying local people on local issues, and ideally relying on local sentencing to put things right. So magistrates are where every case starts, and magistrates hear cases at first instance, so they do trials of particular kinds of case. So there are 3 kinds of criminal case in layers: summary only, all of which are done by the magistrates; indictable only, all of which is done by the Crown Court, jury, trial, now, and in the middle, called iu3a offences, which are between the 2 kinds. And you can decide if you're a defendant to be heard on your iu3a charge by the magistrates, or you can elect trial to the jury. You have that option, and the magistrates have a say also in which direction iu3a cases go, and that is how it all works. Summary only, I think the magistrate's jurisdiction currently is that they have a maximum sentence of 12 months imprisonment that they can use. So that gives you some idea of the level of cases that they deal with. That goes up and down. It's been 6 months, 12 months, 6 months, but I believe it to be 12 months just now. So the other role that magistrates have is an appeal jurisdiction. So if I'm convicted by the magistrate's court down here on a summary or on an iu3a offence, when I said I want to be tried by the magistrates, I appeal to the Crown Court, but not the Crown Court with a jury, a Crown Court judge sitting with 2 magistrates. That's the appellate process, and that is as of right. So if I come to court and I'm convicted, I can just go to the Crown Court without leave of the Crown Court or anyone else. I can just take my appeal to the Crown Court, and it is done by a complete rehearing. Now, that has lots of pros and cons. I'm just being comprehensive about how the magistrate system works at present. But firstly, if you consider, for instance, in the youth court, a young woman claiming sexual misbehaviour by a young man, very hard for her to give her evidence, very hard for him to be on trial. The whole thing is resolved, he's convicted, and then of course, why wouldn't you? You would of course appeal and just have it reheard, which means not only does he have to go through it twice, but she does as well. Very often, of course, that doesn't happen. Witnesses just give up at the first hearing. So there is probably something to be done there, and here are the problems. Having set roughly out how it works, that's what the magistrates do, and all the rest of it is done by the Crown Court, by jury at the moment. There are problems. Firstly, the magistrates have a backlog of cases nationally of over 360,000. And that is a lot of cases, though by and large the magistrates' cases are shorter and quicker than the Crown Court ones. I can tell you there will be a lot more soon. There is a particular issue which some of you might have taken a real interest in, which is that an organisation called Palestine Action has been proscribed as a terrorist organisation. Many people of, I guess not our age quite often, have been arrested for protesting, I think essentially against the oppression in Gaza, but holding something that says Palestine action. Over 2,000 arrests. Think about 360,000 cases in the backlog and 2,000 more arrests, all in a short time, all of whom have to be tried in the magistrates' court for this offence. There's an application to the High Court to say that Palestine action was unlawfully prescribed, and if that succeeds on November 25th, it's worth keeping an eye on that date, then all of these 2,000 cases presumably just disappear because there was no offence to, should have been no offence to commit. But if not, a district judge is currently trying to organise to get them through in a reasonable time, trying them in groups of 5 people, trying to get 5 trials in a day. And I can tell you that is not going to be a recipe for very satisfactory justice, though I understand it. So, maybe more problems for the magistrate to come, but although the 360,000 backlog is a significant one, the general view is that the magistrate's court is an efficient organisation, that it works and it gets stuff through. So let me tell you more about that when I turn to the Levison review, as I do now. Many of you will be well aware that because of that backlog, but because of the next chapter, which is the Crown Court, there is a real need for change in how the court works. So the Crown Court, where juries at the moment decide all the cases, and the most serious cases must go, and many, many others do go. So Sir Brian Levison, who is a former judge, was brought in to tackle the backlog of cases in the Crown Court, which is 78,300 as of yesterday. It is continuing to rise by 10% a year and not being reduced. The practical consequences of that are, for instance, in London, I know that there are more than 100 cases already fixed to be heard for trial in 2029. So given that it'll have taken a year or so to get to the point of fixing the date, we're talking about crimes committed probably last year, which will not be tried until 2029. And just imagine, firstly, how witnesses will cope, how people who've been, badly beaten up in a robbery, or a woman who's been raped, how they all cope with the trauma. Now, I know it as I do from the Victims Commissioner role, that people are in that position, like wake up every morning and remember what's happened, and remember too that they're going to have to relive it in front of a public place at some stage, and now the some stage is 5 years long. And what about the quality of justice? I mean, whose memory is going to be infallible after 5 years? Even the statement you've given at the time may make relatively little sense. So I think you now, in a couple of sentences, have got the reason why Sir Brian Levison's review is extremely important. It just cannot work in the way that it is going. So what caused this backlog? So Sir Brian says, underfunding, full stop. Fewer courts, many courts have been closed, lots of magistrates' courts have been closed, whereas local justice was really a hallmark of that system. But Crown courts have been closed, they're very badly maintained. So there is a court called Snaresbrook over in Epping, which is probably, I think, the biggest Crown court in the country, in the sense that it's got 20 courtrooms in it. But if you go there on any given day, 2 or 3 of them have got leaky roofs, so they won't be used today. The central heating doesn't work in some of them, so they can't be used in the winter, and all kinds of things go wrong because they haven't been maintained properly at all. There is also a much smaller workforce in the Crown Court now. There was something of a cull of staff, part of the, as I say, probably it's disregard that's led to this underfunding, but whatever it was, but there's lots and lots fewer criminal barristers now, because as the funding for courts went down, the funding for legal aid didn't go up either, and so a lot of barristers can earn twice as much money in the civil court, or in the family court, indefinitely, than they can in crime, however much they want to do that. So all of that has thinned out and become, as it were, less experienced. In 2019, the backlog, which is now, as I've said, 78,300, the backlog was 33,000. So it has really skyrocketed. He doesn't think that the pandemic played a huge role because the courts were pretty quick to get to, obviously some judges must go to Tesco, because you can see plexiglass in Tesco like almost as soon as the pandemic started, protecting people, and very, very quickly that was around jury boxes in the Crown Court separating people. So it wasn't a great delay. There was a bar strike for pay. Doesn't blame that either. He just says it is irretrievable. We cannot get it back. It has gone, and it has gone through underfunding. So the current Secretary of State for Justice, who is David Lammy, has just paid, as soon as he came in, for 2,500 more court sitting days every year going forward, and it'll help a bit, but that's nothing like enough. So Leveson was tasked with solving this problem and getting the courts functioning again. And the essential basis of his plan, I don't think I'm misrepresenting it at all, I've heard him talk about it a couple of times, is to move things downwards. So, firstly, what won't be moved downwards are very serious criminal offences. Indictable offences will still get a jury trial automatically. They will be reserved for the Crown Court and the jury, and nothing is going to change that. An extension of a principle that started a few years ago, he argues for, which is that complex cases, and the judge charged with a case will decide what's a complex case, will be heard by the judge on his own. So these will be complex frauds. People go to jury service for a maximum of 3 weeks, but complex frauds can go on 6 months or a year, and that's wholly unreasonable on people's lives. And also, jury trials are infinitely slower, as you can work out, than any single judge type trial. And if they're extremely complex too, given that you've got to go at the rate of the slowest, or the least familiar with whatever it's about. I mean, it could be about copyright or patent or monopolism, merger, anything at all. Then it is a slow process indeed. So judges will decide which ones, but complex cases will go out of the jury system entirely, and the judge will sit alone. Very interestingly, I think, defendants will be allowed to elect for trial by a judge alone, i.e. opt out of the jury system and just rely on a judge. I think I'll come back later to this, but when that was first mooted as an option in 2003 for the 2003 Criminal Justice Act, I was an MP, and I and other Labour lawyers tried to stop that from happening on the basis that it is capable of being abused, and that someone will come to court and say, oh my goodness, that judge is a terrible sentencer, I don't want to be tried by him, and change their mind and say they'll have a jury instead, and vice versa. And so the worries were that level of manipulation which would look appalling to the public, and also a bit of a worry about a victim. If there's a one-to-one case, and this person is an affluent middle-class person who went to a good school, and this person is a black person from Tottenham or whatever, and the defendant went to the same school as the judge, even though they've never met and they're a generation apart, that won't look right if that judge has been picked by hand by this defendant to try it on his own. So there are all sorts of pros and cons about that. We could discuss it, but we didn't like it then. I'm not sure where I stand on it now, but it's the defendant's right that will be given to them to choose. I will have just him and no one else. So you can see the problem. Maybe a victim would prefer 12 people to consider whether they're telling the truth or whether the defendant is, and that may be a better spread of people. However, the judge has to agree to take a case on, but it isn't clear on what basis they could disagree if the defendant, who is of course the focal point of the trial, wants the judge to do it on its own. This is a new chapter, really opening much wider for us. Actually, a really interesting point is that there is this sort of option, not exactly the same in Australia, in some states, in New South Wales in particular. And judges sitting alone have a between 9 and 12% higher acquittal rate than juries do. This is surprising, isn't it? Because we all regard juries' judgment by your peers as the absolute bedrock. However, as I say, these judges alone have a better acquittal rate than juries. So, coming down, as we've done indictables, we've done complex, we've done the ones that can be elected to a judge alone. Underneath that is going to be a real change, which is that defendants, who all remember start in the magistrate's court, and if they're on an either way offence, can elect trial or stay put. Defendants will not be able to elect trial from the magistrate's court to the Crown Court unless the maximum sentence for their offence is more than 2 years. So a lot of small cases which have not got a big sentence, the average jury trial, I don't know how meaningful the figure is, costs about $250,000. So something for, £2 shoplifting, that wouldn't happen. In fact, it would have to be more. But a small case like that costs $2 million, takes a lot of time. So here is the proposal: no election for jury trial unless the maximum sentence for the offence, its gravity level, is more than 2 years. Most either way cases, so not the summary ones the magistrates do, not the ones that the indictable ones that juries will do, but most in the middle will go to a brand new division of the Crown Court, which Sir Brian calls the bench division. And this is very interesting because it will consist of a judge and 2 magistrates. So that is actually the same constitution that you have for an appeal from the magistrates, as I've described earlier. But it's a new one for trying factual issues at first instance. So people won't be able to elect. If they want to go to the Crown Court, they will have to go to the bench division of the Crown Court instead of the Magistrates' Court. And the bench division can take cases up to a 3-year maximum sentence. So I can't think that division is going to last for long. You can't elect if your sentence is not more than 2, but the bench division can take it up to 3. My guess is those would get rationalised out, and it would be impossible to elect unless the sentence was 3. But there is some choice distinction there, the merits of which I can't quite fathom. But there it will be, and that will be the answer, and that is the end of the jury trial for a vast tract of people who come to be tried by our courts now, and who do get tried by their peers. They will only in the most approximate way be tried by the peers in the sense that there'll be 2 new people involved instead of 12. But interestingly too, it's quite a different process, because anyone who's been on a jury or seen a film knows that the judge is the judge of law and directs the jury about the law, and they must take the law from that person. But the jury are finders of fact, and judges have to say there's something about, if I appear to be expressing a view of the fact, just ignore it. I don't mean to, but that's your job, not mine. Now, all 3 of these people, the judge and the 2 magistrates, will be fact finders. So all 3 of them will have to do that jury role. The judge presumably giving guidance of some kind about the law, and then my guess taking it from him that he will have a big say. She will have, I think, a big say, almost inevitably. And so, may we be looking not only at the judge-only trials, either because they're complex or because the defendant's elected, but also judge-dominated trials in the bench division, which might well have a similarly better acquittal rate than those of juries. It's not at all unknown. So that is the big innovation, and that is the big exclusion of juries for the vast number of cases that currently would go to the Crown Court, or at the bottom end. But all of these, as described, are all in the Crown Court, and so they all appeal to the Court of Appeal Criminal Division in those in appeal, as they do now. None of that appeal right changes, but you can see how it will go. Summary or bench division, end of story. Or election for trial, if your sentence is bigger than that, remains possible, and these possibilities of judge alone. Summary stays in the magistrate's court, no change. Magistrate goes on, as I say, it is regarded as efficient. The one big change for the magistrate's court is going to be the appeal process. So I've described it already by reference to that fictional sex offence trial. From now on, there will be no automatic appeal from the magistrate's court at all. You will need the consent of the Crown Court to do an appeal to them, and the appeal will not be a rehearing, it will be a review, which is the process the Court of Appeal Criminal Division uses, which is to say they will have to make the magistrate's court into a court of record. At the moment, lots of magistrates' court have recording equipment because there are some times when people give their evidence long before the trial is played, and so there's the rudiments of good recording equipment there already, but they'll have to equip them fully, just like the Crown Court. So every word, is caught, so that when there is an appeal, it will go to the Crown Court, lock, stock and barrel, and they will look at it and say, was this trial done well? Is the conviction safe? Which is the same test that the Court of Appeal uses, so no rehearing again. And again, I guess that is a substantial sort of time saver in the magistrate's court. Because as I've said, if you're convicted in the magistrate's court and it's something that matters, why would you not appeal, since it is as of right? And so most people, I think, many people, do at the more serious end. So only with the Crown Court, and on that basis of review, only two. So one thing that probably already shines out to you is that we're going to need an enormous number more magistrates. If they're going to staff not only the magistrates' court, but also most of the Crown Court, two at a time. Their estimate is we need about another 20,000 magistrates, and they are going to have to be recruited with care, with all manner of considerations involved. Of course, we recruit magistrates now, but it's going to be a much bigger task. So I've sort of brought it back down again from the top of the Crown Court, and it's now clear. The final, and for me, very important proposal from Leveson is that there should be an enormous number of cases which never go to court at all, which drop out of the bottom of the criminal justice system and are dealt with by out-of-court disposal, which can be, a simple caution from a police officer, which goes on your record for a while, but no action, a caution on condition that, whatever drove you to do it, you put right, maybe you shoplifted, you have to go and do something for the shop or return it or something, a conditional caution. Penalty notices for disorder are quite typical. And what I think is actually the best of all out-of-court disposal are community resolutions, often negotiated by the police. And I had one when I was the MP, so it's quite an old story. There was a really good community resolution which I I just heard of, but they're two young lads who just finished their exams at some age around 17, on their way to good careers. They passed their exams, they were out for a drink to celebrate and did a bit too much of that. And for some bizarre reason, decided that what they needed to do was walk over the top of this car. So they walked over the top of somebody's pride and joy. And obviously they did a lot of damage. No doubt fell off at the end. And they were arrested. And the owner of the car, whose pride and joy it was, probably would have liked them to be hanged. But happily for the officer who came, because you have to say, these lads, behaving like lads do, though in a very unfortunate way, extreme, clearly on their way to something better, clearly a bit of a shame that they fall off now for this, but nonetheless, this guy has been very badly wrong. The police officer very quickly found that the owner of the car had a young boy the same age, and managed to use that to persuade him that what they should do is obviously pay for the car to be put right, and also come and clean it, I think, once a month, do some gardening for him once a month. And it turned out in the end that his son and these two became really good mates, and so far as I knew, till the day I left Redcar, they'd never transgressed again. I mean, that is a really good thing to do for the community, with the help of the police, to sort something out at that level. And so, yeah, I really do compliment Leveson that he has the confidence to suggest something as wholesale as that, which is many thousands of cases, to just go completely out of the criminal justice system. Where they acquire a massive amount of police input, CPS input, court input, timetabling, adjournments, time, witness, and so on, when really that's much too big for the wrong that's been done, which could be put right in this much more sensible way. So that, I think, is going to be if that's carried through, and I think it will be. Of course, it will be subject to massive criticism, because all of this is, as I say, going downwards, and you can hear the voices ringing out, can't you? Everybody's going to be let off, kind of stuff. So people will have to keep their faith. But the options are pretty brutal, like waiting 5 years before you can give evidence in a case of your own, because it is an irretrievable position. So fewer cases overall, fewer convictions overall because of out-of-court disposal, fewer convictions by judges because they might be more lenient than juries, and fewer trials, because another proposal of Leveson is that whereas now if you plead guilty very early in the day, practically the minute the police officer puts his hand on you, you can get a maximum of 30% off your sentence. You will now be entitled to 40% off your sentence, even if you plead guilty relatively close to trial, but not at the last minute. So obviously a lot more people will plead guilty and not have trial. So you can see how it's all down. Fewer cases completely, fewer trials because of guilty pleas, fewer appeals because you need leave, and all of that fact-finding being done in those compartments that are appropriately costly for the level of crime that they're representing, I guess. So here's the question, will it happen? My guess is yes, very quickly, and particularly the loss of jury trial. Because, as he says, he doesn't relish doing this, but he thinks it's absolutely unavoidable. And if it's going to happen, I think it needs to happen quickly, I guess. It will. So the other thing is our prisons, which, despite the fact that there's not much going through the ground, are very full of people, it's slightly baffling, but nonetheless true. So we have 88,000 people in prison at the moment, almost full. And according to the report that was done by Dame Anne Owers recently about the way that prison population had gone, the prisons were almost full and couldn't take another person 3 times in the 18 months between summer 23 and autumn 24. 3 times, almost at the stage where there was no space for anyone, and they're already, 2 to a cell, 3 to a cell. So it isn't that they're in comfort at all. No space for anyone. Come back to police custody no space in police custody. What can you do? You can't arrest anybody, whatever they've done, because there's nowhere to take it. So it's chaos beyond any a proper visualization. So we have much longer sentencing. Where there was overcrowding when Labour was in government, when I was in government with them, and the overcrowding was considered to be very dangerous at 48,000. So in those years, in the decade that's passed, 40,000 people are in custody and we're overcrowded again. How that's come about is not analysed greatly, but mandatory life with longer tariffs means discretionary life, automatically get longer tariffs, everything else comes up. Longer term stays obviously fill more prison cells. Sex offenders who live long time, you are often not brought to book until much later in life, are old people when they get into prison and need more care and more space, as it were. Terrorism, and then of course there's the IPPs who've been imprisoned on an almost interminable basis with no obvious means of getting out. And then there are many thousands of short sentences which also fill up the courts. So the odd thing about this, and I'm turning now to the review of sentencing that's been carried out by David Gauke, former Conservative Secretary of State for Justice. The odd thing about 88,000 prison population and overcrowding still, compared to 48,000 in the 20 zeros, is the crime's down. Crime's been coming down for many decades. The crime survey for England and Wales shows violence, burglary and car theft down since the 90s by almost 90%. And still we have this massive prison population. Robbery down 3% a year since the 90s. You know, lots better security in homes. Cars have theft engineered out, and really public spaces with massive surveillance, all playing a role, but a very bizarre position where the prison population goes up and up and crime goes down and down. But that's where we are. So David Gauke, who was the Secretary of State for Justice in the Tory government, very middle of the road, he appointed me Victims Commissioner, though I was well known to the Labour person. The advantage he had as the choice to do the sentencing review, the government knew what he was going to say, because he already said it when he was Secretary of State. Indeed, the truth is that the government knew what Leveson was going to say as well, because he'd already said it. He did a report on the efficiency of the criminal courts in 2015. So this is smart stuff, isn't it, really? You know what needs to happen. You know who knows what needs to happen, and you ask them independently to find it. It makes loads of sense to me. What he is advocating across a whole range of stuff is firstly a big presumption against short sentences of imprisonment. So if a person gets a sentence of imprisonment of less than 12 months, the re-offending rate within the year of them coming out is 62%. 62% just, hasn't made any difference. In fact, it may even have made them worse. 62%. From a community punishment, it's between 28 and 35%. So it's half as much for not sending people to prison for terms where there is nothing very constructive to be able to do. There are no courses, counselling, whatever is their criminogenic driver, there isn't much opportunity to tackle it in custody in that very short time. And so what he does is he snatches somebody out of, whatever their life was, their family, their home, maybe their job, whatever it was, puts them in a box and gets them out again in 12 months when they have nowhere to go back to, nothing to go back to, nobody left around them, and they have to start again having a criminal record as well, or a bad sentence of imprisonment. It particularly horribly affects women. 17,000 children lose their home every year because the mother is put into custody, and overwhelmingly women are put in for less than 12 months because they do things like shoplifting, dealing in oppressive partners, drugs, Not, serious stuff, rarely violence, and yet they too are snatched, as I described, out of the family. Family relationships for men who go into custody are a support. Family relationships can help them to do better whilst they're in and when they come out. For women, it doesn't work like that. The house usually just doesn't carry on. The children go into the care of a relative or right away into care. So as I say, a large number of children taken away from their families. And so that collapses. The home doesn't keep going. She loses a job, a home, her children, and her social acquaintance to go into the custody, to come out. And if, as many people are, 67% of women in prison, the last time the Prison Reform Trust did some work to count it, 67% of women in prison there had suffered either domestic or sexual abuse in the course of their lives. So, have been more sinned against probably than the sin they've done, but there they are. Anyway, I don't have to argue for what Gork says, but he says, and I think he's overwhelmingly right, this is just silly. Short sentences are just silly for people like this. They'll be needed in exceptional circumstances. He's not going to wipe them out. But he wants community sentences and he wants suspended sentences, which invariably have a component of treatment or whatever it is, obligation added as well. I'm on the Women's Justice Board, and we are worried about the way that proposal, no short sentences, except in exceptional circumstances, is being put into legislation. So he said community sentences, suspended sentences, fine, but none of this 62% recidivism rate stuff. However, the law, as it's drafted in Clause 1, said any sentence under 12 months must be suspended. Now that's going to stop magistrates from looking at community punishments too, because it says must be suspended. And the problem, if you think about women, because I've just said I'm on the Women's Justice Board as well, if women have got those difficulties that the Prison Reform Trust found among 67% who go to prison, if they've got issues to resolve, that they've been abused and they're traumatized, or they've taken to drink, or they've stolen for survival, or whatever it is, if they've got complex needs, as many women in custody have, the problem with the suspended sentences is it starts today. And if I fall by the wayside from today, I will go back inside. Whereas the process of taking the counselling, getting the advice, getting the support, of course, takes time before it has impact. So in that sense, suspended sentences make very little sense to women. They almost invariably break them quite early on. Get the sentence, because the rules are really strong, you must impose it if it's broken, and they can break it even by not turning up to a probation appointment, and then they're inside. And if it's another offence they've committed, they'll get a little bit more custody. And so, the whole thing can in fact make women get more custody than if they weren't under the acts of a suspended sentence. You can see that principle, and obviously the principle would apply also to males, many of whom are also undereducated, not haven't had privileged backgrounds, have got trauma, maybe ADHD. Also, you put them on a suspended sentence. That's the problem. They haven't escaped from prison at all, and what might keep them out hasn't had a chance to bite. So he said differently. He said community sentences are just as good, but that clause, we've put in actually an amendment to that clause from the Women's Justice Board to try and get it better. But there we are, that's his big proposal: strengthen alternatives to custody, enhance community penalties, lots of stuff about prison at home being tagged, using new technology, and hopefully using somebody like Sodexo, but rather better. Progression from custody by good behaviour is very controversial, because the good behaviour is not very specified, but focus. And so people are worried that if you just don't misbehave in prison, you serve your time, you will soon come out by not causing trouble. That needs more definition. He wants to focus sentencing. He wants packages of it. Women, prolific offenders, drug and alcohol-driven offenders, older offenders, sex offenders with tailored interventions, which is all very sensible. And like Leveson, I guess it has to be said that he is going to be taking it downwards, and that may be harder for people to digest even than Leveson's proposal, but there it is. There seems that unarguable point about short sentences being worse than no sentence at all. So, what I would really like to talk about for the next 20 minutes, but I'm not going to relax, is victims, because I haven't even mentioned victims, and they are dear to my heart, and I tell you, they don't get a good deal in the criminal justice system. They tend to suffer injustice from the way they're treated, by disregard from the agencies, re-traumatization by the process itself, and really there is a whole lot to do. When I was the Victims Commissioner, I tried to construct a sensible strategy about how to stop it being so. Clearly the focus of the criminal case is on the defendant. I arrest him, he prosecutes him, in court he prosecutes, he defends him, the jury decides it, the guilty judge decides it, it's been done lawfully, and nobody's taking any notice of the victim, who is, as one academic said once, just fodder for the criminal justice system, has to come in as if he were a bystander and tell the story of what happened to him, but it's about what he did, not what happened to him. And of course, victims are very, very disempowered people. They're very fact of their victimhood makes it impossible for them really to fight for their rights. And who in this arrangement has got the victim's rights in mind? So I did try to construct, because it's quite a piecemeal job, create the victims commissioner role. You move from this kind of victim to that kind of victim, and I tried to get a coherent plan of how we could recategorize victims so that they became participants, i.e. with a formal role in the criminal justice system, not parties, with an axe to grind, but with a role that had to be respected. And so I did try to draw that together. And if I had another little while, I'd tell you all about it. But you know what? You're going to have to buy my book. And I'm going to have to write it.
So, do we have any questions after that brilliant talk? We have several people. So we have one microphone. Okay, could we have the person furthest back? Could you put your hands up again? The one in the red and black jacket, in the middle of this 7th row. And then I will take 2 more questions before I ask Damien and there to answer them in bunches of 3.
Thank you very much. That was very interesting. I hope you can come back to speak to us again about victims and more, because there obviously is more. Is there somewhere that we can, apart from your book, is there a website or somewhere where we can read? Because there sound to be things that we ought to be maybe writing to our MPs about. Thank you.
Okay, the second, could you put your hands up here? The one in the dark red jumper here, 3rd row.
Just a quick comment on the prison population. You didn't mention people on remand, and are they not blocking all the lots of spaces and also costing us an awful lot?
Okay, there was another person here. This gentleman in the dark suit. Okay, that's your first 3.
Thank you. We mentioned briefly we need a lot of new magistrates. Could you briefly outline the timescale it takes to become a magistrate and what kinds of backgrounds or qualifications we might need? Thank you.
Sure. Well, thank you very much for those. All very interesting questions, if I may say so. I do think there is stuff that you could look at and consider writing to your MP about. I mean, I don't know where everyone lives. Are we in Jeremy? Are we in Jeremy Corbyn's seat here? But there's also Emily. Yeah, Emily, who was in Chambers with me for many, many years, who I know really well. I think the first thing you could do is consider that point that I made about the slip between Gawk's recommendation that you don't use prison sentences of under a year and you do something else. And the slip that's made it, just suspend it. And the damage that's likely to cause to people who are otherwise, without that subclause, there is legislation elsewhere that allows a magistrate, even when they've decided that the person has done what we call cross the custody threshold, even when they've decided that, they still have, if they wish, a right to give them a non-custodial sentence. And that, I'm afraid, will disappear from magistrates' consciousness because of clause 1, which were the new rules. So I think it is worth trying to get some purchase from MPs on the amendment that we have put in. Where to look for these things? Leveson is online. If you just Google Leveson Review, it's Leveson, it comes up. And it's about, I mean, characteristic, he's a fabulous bloke, Leveson. I really admire him. It's a long report, but there is a summary too as well to get the essential points. It's pretty well in depth. And Gawk, the sentencing review, likewise is online, so you can look it up, and they again are pretty reasonably in depth. Remand, yeah, I think that figure includes remand because it's the whole prison population. But I mean, remand prisoners are obviously the primary victims of this dilemma. And I have wondered about what could be done and about remand prisoners. Clearly they can apply for bail, but the die can get cast, I think. And if they've been in prison for a long time, which they might well have, then, and depending on the offences as well. But I think there will be, and I've been looking for an answer to this, I think there will be people who are on remand having elected trial to the Crown Court, because they didn't want a magistrate trial, they wanted a jury trial, who, if they'd stayed in the magistrate's court, would have served their sentence by now. Because the magistrates can only give you a year, and they'll have been in longer. And so what you really need is an ability to de-elect back down to the magistrate's court, so they can be sentenced and discharged. And no one has yet come up with a way of doing that, but I think that is a key part of it. And obviously, bail applications are the rest. But somebody who was trying to escape by going to the jury from a 12-month sentence or a 9-month sentence has really snookered themselves completely by doing so. And it's no way that lots of people who will be acquitted in the end. I mean, 33% are acquitted. Judges acquit more, as I've said, will be acquitted in the end, and they're locked up and they've lost everything because of this delay. So you have a very good point there. What you have to do to become a JP, I suppose you don't do any crime, at least in the short term. But I think there is a whole process to be gone through. Clearly, you have to have good character. You have to tell them all about yourself. They will have to be satisfied that you're not, involved in anything unsavory, the usual kind of thing for a high-level public service. But it is an extraordinarily good role to do if you can. And what is very good about local magistrates, thinking local about it, is that they tend to make sure that they know all the sentencing options that are available. So, you might have a special scheme in a bit of Islington that deals with a particular kind of offender. Local magistrates tend to make it their business to get to know that that's there, so they can use it. So it's a hugely important role.
Is a JP the same thing as a magistrate?
Yeah. Yeah, just justice of the peace.
Okay, now over to this side. Who have we got on this side? Robert?
A comment on efficiency.
In the magistrate's court.
Well, two really.
Maybe the famous answer.
Yes. Okay. In terms of the magistrate's court.
I think wait for the good microphone.
Still not working.
Hello? Can you hear me now? Right. In terms of the magistrates' court, the district judge I knew said that the throughput of a district judge was far higher than magistrates themselves. Yet you have been talking about the need for efficiency, but it seems to go against what you are advocating is to have more GPs as opposed to district judges. And then the second aspect of efficiency is that I noticed that I'm thinking of the case of the tree that was, very famous tree that was cut down. That case seemed to go on for weeks. But although it was a very sad that England's most famous tree was cut down, it didn't seem to be a very serious offence. And why are such resources disposed in that way?
Okay, there's someone else from this side who wants to ask a question. Is there anyone else? Yes, this lady in the black. Oh, you do it first, and then the lady.
I just wonder if you could say something about mental health provision and how it feeds into the issues that you've been discussing.
And then the second row. Oh, you see. Okay, anyone else on this side? Anyone else here? Okay, the lady in the blue cardigan will have to wait for the microphone.
Very much. I may have got the delineation of the system wrong, but you were saying you were saying that people will be able to nominate their judge. Is that correct? They will be able to nominate who?
You can't say, I want Judge Smith.
Oh, right.
No, you can only say, I want judge and no jury.
Okay.
But what I was worrying about is that somebody would say, oh, I'll have jury trial.
Yes.
Or alternatively, I'll have judge trial. And then they come to court, and it's, Basher Briggs, who is sitting as the judge, and they say, oh, I've changed my mind. Yeah, and that looks very manipulative to the public, that the person's picking their tribunal. Whereas the essence of jury trial, of course, is completely random, a bunch of people.
And just secondly, how long would you envisage with your expertise, how long might it take for this to bed in, and would it be in phases, or, because it feels like it might not be in any of our lifetime that we would see this working?
Yeah, so how long will it take to do? I don't know how they'll implement. So at the moment, the sentencing bill has started. So the whole Gork stuff is on the stocks, and it is intended, I think, to be brought in as quickly as it can. There's obviously going to be a level of political opposition to it on the grounds of its kind of softness, I suppose, is what we would have to say. But nonetheless, pretty well, as soon as that goes through, there'll have to be a period of training for the sentencers, and training, I guess, for probation officers who make recommendations about sentencing. But, and then, the equipping, because we have a real problem with our current probation service, they're a great public service, but there aren't enough of them. An enormous number went left when, what was his name, Grayling privatised it, and just have never been recovered at all. Base service is in real difficulty, so there may be a need for some of the non-custodials not to be graded, because have we got the probation services to receive these people and deal with them as we would wish. So I think all of those will be a factor, but it is pretty clear that there is a legal crisis in the prisons, and they've got to act quickly. So I know there will be pressure on to do exactly that. The sycamore, I completely agree. I've lived in Northumbria for a very long time, and it is, kind of cute the way it sat in that space and everybody recognised it. And I think it was, a wanton piece of criminal damage, but it took an enormous amount of time, and it was at an enormously high level. And personally, their sentences were, I think they got 4 years. Chopping a tree down is quite a lot. So I don't know where the balance should lie. The judge is clearly trying to appease public opinion. He thought it was appalling that damaged the symbolism that showed the Northeast was a fine place. But it was, I thought, quite a rigmarole about quite a small, sensationally bad and stupid thing to do. But I didn't know why it took so long. So the other point about district judges. There are people called district judges who sit instead of magistrate. So you have a bench of 3 JPs, which is the choice, or our district judge who is a professional, probably a solicitor or a barrister, who sits in that way and does all the cases himself. That is much quicker than having a bench of magistrates. But given that overall, it's not my judgment, it's the judgment of Leveson and those who put the data into its organisation, given that the Magistrates' Court is fairly efficient, keeping that trial by your peers element is very, very important, I think, and I think that's why, you know, we haven't got just a bunch of lower level judges in the Magistrates' Court, and probably never will have, and we will need more JPs.
So that was Robert's question.
That was Robert. And then how the mental health services work. Well, I mean, it depends on what level, but if we're talking about alternatives to custody, then the probation service will have to do an assessment of the person, if necessary, get some mental health input from local resources and assess what treatment they need. There are, of course, orders if somebody's unable to plead about a case because they're so distraught they don't make any sense at all. There are some defences, which are mental health ones, which can come into play. But so far as treatment is concerned, the way it's tackled is by the probation service acknowledging that there is an obvious need and then moving them over into some special assessment. I'm unconvinced that it is very, very readily available, particularly I think CAMS, which is for young people, I think is very stretched at the present time, but that's the mechanism.
Shall we have another round of questions? Gosh, this lady here.
Is this working? Is this working now? Yes.
Yeah.
It's about the lessening of a sentence when an accused pleads guilty in the early stages. I worked as an interpreter in courts, and I could be wrong, but I used to get upset at the accused, who didn't speak English, being persuaded to plead guilty even when he thought he shouldn't, and it seemed possibly he wasn't, because he would get a lesser sentence. And now that encouragement is going to be increased. Yes? Thank you.
And the lady in the mauve jumper, 7 rows down. Did you hear that?
Thank you very much. I really thought your talk was extremely interesting and very informative. A couple of quick points. One is you briefly mentioned probation service, and I wonder if you've got any ideas about how that could be improved or changed. And then secondly, you talked about the reduction in reported crime, and I'm not sure that that's how people perceive things at the moment. But is that because, I'd be interested in your comments, is that because people think it's a waste of time reporting crime, or what, or something else? But I'd be interested in your views. Thank you very much.
Was there someone else in that area? Okay, just behind her. Yes.
Thank you. Speaking as a magistrate, I would encourage those who wish to go into this to have a look at the website. There is a very rigorous recruitment process, as there has to be. But the issue is that the recruitment process at the moment is far too lengthy. And I wondered if there were any proposals for streamlining that in any way. And just another quick point. I agree with the point about out-of-court disposals, but you need a big infrastructure to support that. So are there any plans, any proposals for enhancing the infrastructure to support out-of-court disposals?
So, thanks very much for pointing out that there's a website. I agree entirely that the process for selecting a magistrate seems to be very long. I had a friend who retired. I think, is it the case that you can't sit beyond 75? I'm not, yeah. So she retired at 70 and decided she wanted to become a magistrate, thought she'd been a solicitor. I had a few years, and it somehow took so long that by the time, they were ready to say, you know, we would think about her. They decided the training wouldn't be worthwhile because they'd only have her for a year or so. So it is incredibly attractive. Another much younger person who I knew from Parliament asked me to be a referee, and I wrote a reference, and they rang me up and were very careful, and I, you know, talked her up appropriately because she's very good. And months and months and months and months went by. She had no idea. She got an invitation to attend some sentencing conference, so assumed that that meant she'd be appointed. Rang them up, and they said, oh, no, that's a mistake. You haven't gone through is it called the county committee? There's a committee, isn't there, locally, that approves local magistrates for local jurisdiction. You haven't gone through that. Obviously, you know, a rabbit had come off somewhere because she was, in fact, appointed. And she now enjoys it very much, and I think, you know, it's a shame we lost my other friend, who would have had, you know, 4 years, maybe if it took a year instead of 3, to put plenty of service back in. She's been a good solicitor, so it does need speeding up. I don't know if there are any proposals, but I would say, and Leveson will have thought of that, I think, that, you know, if we need 20,000 more, we can't be taking that kind of time to appoint them. It's got to be very carefully done, obviously. And out-of-court disposals, resource, I mean, will obviously be needed to boost the availability of all of that kind of stuff. Many times it's the police who do them, you know, who trigger them anyway in the course of their work and do it very well. And there is a kind of incentive in a sense, because if they don't, if they can resolve something and they don't have to do, you know, all the referral forward, all the paperwork, all the recording, and so on that follows if they're going to take it to court. So there is something to be said for that from their perspective, and that's where many of the ones I'm aware of have been initiated. There clearly does need to be an infrastructure for them, and there needs to be scrutiny, doesn't there? It's all very well saying out-of-court disposal, but who's doing them, about what, about where? And there are now, the police and crime commissioners do have scrutiny panels of out-of-court disposal, and every month or so, I think they've got CPS, magistrates, so there's somebody from the police, but somebody from the police crime commissioner's office, who is not police, of course, it's civilian oversight, then get together and look at a particular kind of out-of-court disposal that's been done on a particular theme to see whether they feel the rules are being kept and whether it's of the right quality. That seems to be essential, because I do welcome it, but we are throwing justice to the four corners, aren't we? And it does need to be somehow kept an eye on. Well, I mean, the probation service is a problem which does have to be rebuilt, and it is very difficult. I think when she was the Secretary of State for Justice, the current Home Secretary funded about 1,000 new probation officers to be trained. A problem about it is that they are trained on the job to some extent, so you have to take somebody partly off their own duties in order to train that person. So it's a slow, cumulative process to increase them, and you know, there is a very real need for it to be boosted. It was an appalling blow against them. And the lady was worried about too ready guilty pleas. Yeah, I mean, I see the point in the States, as we understand it, don't we? Plea bargain is the name of the game, really, and not that many cases go to trial. So it's a worry. There are currently very, very decent, so I'm not saying they're perfect, protections, you know, about what the barrister who's defending or the solicitor who's defending has to explain, and how the judge has to understand what's going on, and of course it has to be legally sound. You do very occasionally get guilty pleas to things that aren't crimes, you know, because it hasn't been done properly, and then the CCRC has to unwind them. But it has to be done with a great deal of care, or else we will get into that position. But I think, you know, it has a lot to say for it as a proposal to cut the bulk on courts.
I think we should now draw to a close, and I would like to thank you very much for a really thought-provoking talk to the Islington iu3a, and we really appreciate your time, and there's a little gift for you.
Thank you very much.